there's a participation requirement, which you can either ask questions in the group, or you can do it online. But I expect you to do it for at least half of the sessions, okay? And the third is to write a reflection. So those are the requirements. If you have any questions, let me know. I'm Leslie Francis, and I'm easily available. My office is just down there and over that way. So anyway, if there are, that's how the quote colloquium works. So maybe I'll repeat it because I see a couple of people who I think are registered who just came in, because I did look at numbers. So as I was just quickly saying, the requirements are to come, to participate, and to enjoy it. This is a sort of experimental course that we have here at the law school. And to write a reflection at the end of the day, which are due any time by the end of the law school semester. And that's all explained up on Canvas. You're welcome to talk with me if you have any questions about how all this is going to work. Our next speaker is Lisa Gross-Sun from BYU, and the remainder will be a mix of people from the university and the community. And we've got Ann Armstrong from Intermountain. We've got Mark Leinhart from the university's, he's the university's conflict of interest officer who's been working with Professor Contreras on some things. And so anyway, the way we do this format-wise is we have a speaker, and then it can be sort of Q&A, it can be formal talk, Q&A, it's kind of up to the speaker. And we follow that with refreshments. And I want to say that refreshments are as important as the rest of it, for a couple of reasons. One is that refreshments are good, but the other is that one of the goals of this is to enable you to network with each other and with the speakers, including folks from the community who do health law, or issues related to law and the biosciences, with faculty, with maybe other people from the bar who may come. We sometimes this comes with free CLE, so there are sometimes people from the bar who come, and also with our speakers, and maybe more importantly than anything else, with each other to talk about what you thought about today's discussion. So I've just told you about the way this is going to be structured. Today's discussion talk is Professor Craig Konnoth from our neighbor to the east, our Pac-12 neighbor to the east, I should say, the University of Colorado at Boulder Law School, where he teaches health law, civil rights, issues with LGBTQ rights. I've been asked how to, he's also got interest in health data and privacy, and that's where I met Craig. Some of the rest of us, I can send around a lovely, I thought about putting it online, but then I had to ask their permission and I didn't have time to do it. There's a lovely selfie with Professor George at the most recent ALS. So you've met some of us, and we've enjoyed meeting you, and we hope this will be the start of more. So thanks so much, and let's get started.
Yeah, absolutely. Leslie, thank you so much for having me. So early in the semester, we haven't started classes yet, so it's actually a great way to end a vacation. I was actually saying, so I live in Denver, and I teach in Boulder, but Denver is getting more and more organized, and Salt Lake City is looking really beautiful and charming. So it's a beautiful way to end the holiday. So as Professor Francis was saying, I focus in two areas. I look at LGBT health issues and health data policy. And in the LGBT context, there have been debates ranging for years as to whether trans individuals should use disability frames to seek rights claims. And I've written in the past about how the gay rights movement in the 1960s sought to avoid medical frames and rejected previous activists' attempt to use psychiatrists and others to frame their rights claims. But even after that approach in the gay rights movement, recently there has been a push within the gay community to embrace the use of Truvada, pre-exposure prophylaxis, that prevents the contraction of HIV. And there's been a celebration of what some call a remedicalization of being gay. And that, of course, has led to criticisms from people like Russell Robinson, Kiara Bridges, for those of you who follow some of this work, has criticized the use of medical frames in welfare contexts. And of course, the disability rights movement has written prolifically about how problematic medical frames can be. But despite this critique, it appears that individuals just keep using medical frames to make rights claims. So just last year, trans advocates won a major victory in the ADA context by claiming that being trans or gender dysphoria is a disability. And what's interesting is that even though the Trump administration opposes considering anti-trans discrimination to be considered sex discrimination, they have filed briefs endorsing the position that trans discrimination is prohibited under disability protections. I don't know why, footnote, so don't ask me, but I'm just saying the way. So I thought I'd examine this phenomenon more. Now, legal scholars, including some of the ones I mentioned, tend to look at this phenomenon in specific contexts, welfare contexts, LGBT contexts, etc. And non-legal critiques that look at medicalization more wholesale don't consider the advantages. They sort of present the various problems. And so I wanted to look at this more broadly, and I expected various possible outcomes. Either happens or doesn't happen. It's a good idea or a bad idea. And really, to boil it down, I wanted to answer three basic questions. Number one, do people actually use medical frames to make legal rights claims? Number two, what are why are they doing it? Why is this happening? Why do they think it's a good idea, if it is happening? And number three, is it a good idea? Right? Are they correct in thinking it's a good idea if it's happening? Right? So those are the three questions I'll briefly discuss today. But even before I could get to those questions, I had to answer a conceptual question. Right? So this is step zero for those of you who are Chevron fans, right? I had to figure out if there's anything common across all of these disparate groups, which have a range of medical conditions or phenomena, really, right? So I had to figure out if I could talk about them together, especially given that most of the literature on this issue is condition-specific. So I looked at the medical and the legal definitions involved. Now, there is often contestation as to whether a specific set of symptoms constitutes a particular medical condition, or whether a particular condition is a medical condition or something else. So, for example, whether a certain set of symptoms constitutes gender dysphoria, that can be controversial. And beyond that, it can be controversial among some people as to whether gender dysphoria is actually a medical condition. And some might even claim that while medical institutions might recognize a condition as medical, it is not actually medical. So despite the disparity and the contestation, there were unifying themes. The American Medical Association distinguishes between disease, disorder, and condition, but recognizes all of them as medical designations of some sort, what I call a medical status. And laws across the board And so laws across the board look at whether what is involved is a disease or an alteration of bodily structure or an impairment. Indeed, the concept of impairment is a threshold across nearly every legal definition except in the tax code, which They just do it to be difficult, I really believe, right? So the designations often travel from one context to another if you look at the history of the law. And the point is, though, that not every deviation from the norm can be called medical. There is something more. There must be a characteristic that we think of or claim is medical. And what that characteristic is, I believe, is historically constructed, right? You cannot just walk into a room and say, oh, this is now medical. Right? You're generally working within pre-existing limitations, just as within the law, you cannot walk in and say, hey, this is a new legal rule. You're sort of relying on what has come before you, right? But at the end of the day, it is a historical phenomenon rather than an objective fact. It is historically constructed. And medical status claims are deployed for specific purposes in specific contexts. And the question is whether the specific audience recognizes that particular status is medical. And of course, if you're talking about legal rights claims, you will only get rights if the court or the particular legal audience, the legislature, whoever else, recognizes this is a medical condition. Because it doesn't make a difference if your grandmother thinks it's a medical condition or your friends think it's medical. You need courts, legislatures, and others to recognize, say, okay, fine, being trans is a medical condition. Chronic fatigue syndrome is a medical condition, and that's the only way you can get rights coming from it, right? So that's the basic point. How do I conceptualize medical status? Socially constructed, recognizing, relying on pre-existing social definitions. So then I get to my first task. Are people making these claims to a significant degree? The short answer is yes. The kinds of claims I look at can be broken down into two types. The first are formal rights claims, where advocates seek concrete benefits, and non-formal claims. Formal claims involve those where plaintiffs claim that they meet these kinds of formal legal definitions to get concrete rights and benefits. There has been an increase in these number of claims, most of which involve routine claims and illnesses. And I won't go to the procedural detail of how people make these claims here, but suffice it to say that there's medical expertise, often battling medical expertise, involved at all stages. But there's also an attempted expansion in definition. So think about this in an impact litigation way for those of you who are interested in that. The idea is to expand medico-legal definitions to gain access to rights, just as one might expand the definition of equality or due process in doing your standard impact litigation in the Constitution to encompass more groups or activities. The expansion here, as it does there, seeks to include contested categories, right? And you can see the illnesses I picked are contested, historically contested illnesses. I'm sorry, it's a little small, but fibromyalgia, chronic fatigue syndrome, ADHD, PTSD. And in the paper I talk about others, and there's a long appendix, which actually I'm not sure if you guys saw. So the kind of legal contestation over formal rights claims. So many of the rights claims we just never see, right? It happens at the administrative level, rights are granted, etc. What's fascinating is that the litigation has also increased dramatically. And the question is why do we see this increase in litigation? Because there's legal contestation, and the legal contestation occurs for three reasons. Reason number one are situations where the legal definition of what a medical status is narrower than the medical definition. So an easy example is in the ADA context. In order to get coverage, you've got to prove that you have an impairment that substantially limits a major life activity. And so there is contestation over what a substantial impairment is, what a major life activity is. So for example, in the Fourth Circuit, driving is not a major life activity, right? Which I think is only true in New York City. But your social interaction is a major life activity, right? So awkwardness interferes with a major life activity, or conditions that create social awkwardness. So that's one situation. The legal definition is narrower than the medical definition. Another situation is where the medical definitions themselves are unsettled, right, within medical institutions, or at least so the litigants claim. So there was a case called O'Donovan versus the commissioner of IRS, where the IRS claimed that actually, this is a 2010 case, that gender identity disorder, as it was known at the time, was not an established medical definition, right? It was completely wrong. They were more or less laughed out of court. But litigants will claim that the medical establishment doesn't recognize this as a definition. And then third, there are situations where medical opinion is settled. But the law says we are not going to follow. In our definition of of a medical status, we aren't going to follow the medical establishment. An easy example of this is the ADA exclusions, right? That exclude being, gender identity disorder, that exclude kleptomania, that exclude various other kinds of addictions. Established medical opinion, and therefore you have special exclusions for them. But there's also advocacy. So far I've been talking about formal rights claims, right? You fit within the statute, you get anti-discrimination benefits, you get whatever else. But there are also informal rights claims that don't fit within formal statutory definitions. So I could talk here about how advocates have presented the opioid crisis as a medical problem, even though the ADA or Social Security will not cover it. This contrasts dramatically with the way the crack epidemic was framed, which was presented as a criminal problem, right? And framing it as a medical problem blunts, some believe, the people's attitudes towards opioid addicts. Being from Colorado, I should also talk about the medical marijuana movement. Right? The pot advocates use medical frames to destigmatize the use of marijuana. Though I don't think there's any immediate chance of Medicare offering. So again, no formal rights, unless you know something I don't, right? So anyway, it's never, who knows what's going to happen tomorrow, frankly, so with this administration. I could also talk about social determinants of health and how the international diagnosis system, known as the ICD, in its last few iterations have begun to include diagnosis codes, for homelessness, for poverty, etc. Right? So literally, So ICD-9 began recognizing these so-called social codes, I believe they're called. They're Z codes now, they were B codes. I don't know what ICD-11 is going to do. But instead, let me put up this extract from the Washington Post advice column, Dear Amy, and other advice columnist fans like me might have their own favorite people like Dear Abby and Dear Prudence, but Amy's pretty good. And so here the writer begins to feel better, not when she was treated, but, quote, as soon as she got a diagnosis. And Amy urged her not to, quote, blame herself for a character flaw when she was actually sick, right? So there's clearly no legal advocacy here, right? But by calling something a sickness, Abby treated the advice recipient as not morally culpable. And so indeed, advocates use medical framing even when they aren't actually making medical legal claims. So one example I use in the paper is that of race analogy claims. Kimani Paul-Emile, a professor at Fordham, in a highly discussed paper, talks about how race can be analogized to disability. Not because of any particularly morally relevant biological trait. She correctly says that there's no biological distinctiveness to race. But the point is that just as the burdens of disability occur when society ignores or burdens a particular biological trait, so too in the case of race discrimination. Society increases the salience of certain biological traits like skin color and burdens those characteristics. Now, I don't read Paul-Emile as believing that the ADA will incorporate race as a disability anytime soon. But what I do see her as doing is treating disability as a legally more powerful category. Whether she is right or not, why might she and so many others see medical status as having that kind of power? So that gets me to my second question. Why are people doing this? So first I argue that, that the formal benefits that medical status triggers approximately at least equals the benefits that come from claiming other kinds of vulnerabilities. So let's think about first the context in which discrimination might occur. Anti-discrimination protections, when it comes to medical status, reach most government action and similar kinds of private action as do protections involving race. By contrast, sex discrimination is not prohibited in public accommodations under federal law, like race and disability, or rather unlike race and disability. Next, in terms of content, the rights that medical status triggers includes positive rights, social security payments, disability accommodations, medical insurance protections, FMLA leave. Nothing like this accompanies other kinds of disability, other kinds of vulnerability like race. Right? Maybe affirmative action to a certain extent, but that's not mandated. And if anything, disfavored. And then compared to other non-protected categories like unemployment and poverty, which do have some positive benefits, medical status is far more favored. Government supervision is less intrusive, benefits are far more generous, and the positive benefits are more robust and lasting. As we have seen in legislation that's been more likely to repeal the benefits that come with poverty protections than medical protections, relatively speaking. And so I don't want to overstate any of this. There are many limits in the literature which many scholars have pointed to. There's a lot more work to be done with protecting people who have certain medical statuses. But comparatively, as a legal matter, the formal medical rights are robust compared to those of other categories. And what about situations when formal rights aren't involved? Like Dear Abby. And perhaps more important than a gossipy advice columnist, if anything is more important than a gossipy advice columnist, why do other movements like the opioid movement, social determinants of health, and others, why do they seek to leverage the normative cachet of medicine by claiming medical status? In the paper, I explained that the central debate in bioethics, as well as in lay context, is whether individuals should or should not be blamed for medical ailments that beset them. In these debates, luck egalitarianism tends to determine the outcome. Simply put, this means that if an individual makes choices that she should know would cause her harm, she is responsible. If not, she deserves assistance from society. So if she doesn't have a choice, right, she should be helped. So first I look at survey data. And the data is largely inconclusive, but tends to show that most individuals treat medical harm as less the fault of individuals than other kinds of harm, such as poverty or unemployment. Right? They are therefore much more likely to support medical protections than other kinds of programs. But more importantly, I look at the panoply of statutes. And health policy, if you look at the panoply of statutes, health policy appears to treat medical harm as the result of bad luck or of social discrimination rather than individual fault. Now, some academics do point, so Alison Hoffman, a good friend of ours, and some others, will point to smoking penalties that the ACA imposes, or incentive programs that businesses can impose on employees to go to the gym or stop smoking, right? The wellness programs for those of you who've taken health on policy. And so they argue that by shifting risk to individuals, the ACA actually represents a big shift that is beginning to hold people responsible for their bad health. But what's interesting is that apart from these relatively isolated programs that don't really include much of the ACA, if you sit down and read it, as I'm sure you all have, with pleasure reading, the ACA as a whole was designed to insulate individuals from medical risk far more than ever before. So compare the ACA with consumer programs that free market scholars who truly hold individuals responsible for bad health would like, right? So I'm thinking Regina Hertzlinger or even Dr. Bill Frist, right, the former majority leader, who has a couple of articles in the New England Journal of Medicine where he says, no, look, you've just got to have consumer programs, extremely high savings, health savings accounts, extremely high deductibles, etc., right? The ACA is a move away from those programs. And indeed, if we look at the legislative history, and in some cases the statutory text of the ACA, of social security programs, of the ADA, they all point to bad luck or to social factors as bearing the moral responsibility for the burdens of bad health. This in turn explains why we have the law intervening so robustly to correct harms, because these harms are not seen as the fault of the individuals whom they affect. Compared to other kinds of misfortune, our approach to medical misfortune is far more solicitous. Indeed, empirical evidence shows that recasting other kinds of misfortune, like poverty or homelessness, as a health problem increases support for alleviating those harms. Anyway, the third reason that medical approaches to civil rights works is because they offer both judges and litigants cover. Contrast the following two passages from prominent Supreme Court decisions not too far apart from each other historically. These two decisions really represent very distinctive ways about thinking about legal classifications and protections and who makes them. The first, Cleburne, involved a constitutional question as to whether mentally disabled individuals would count as a suspect group for the purposes of the Equal Protection Clause. And the court expressed reservations. The court said, no, we just have reservations about how courts can distinguish among all the other groups, all the other medical groups who might also claim heightened scrutiny in a principled way. And as scholars have explained, the anxiety of Cleburne represents a broader trend in constitutional jurisprudence. Judges today are unable to agree on facts, especially in the court that we have today, much less on normative principles that determine what groups are politically powerless, that have had a history of discrimination, whose characteristics are immutable, etc. They can't even decide whether the state desire to exclude Muslims in Trump versus Hawaii counts as animus, right? So it's quite hard. So Larry Tribe, who many of you may have heard of, declined to issue a new edition of his constitutional law casebook. And he claimed that conflicts over basic constitutional premises, even intractable divisions between wholly different ways of assessing truth and experiencing reality on the Supreme Court, made him not want to write a new book. Right? Now, these concerns appear quite absent in Eldridge. Right? There, the distinctions between groups appear routine, standard, and unbiased. By deputizing the problem of classification to the medical establishment, the court was untroubled by the lack of principal distinction. Now, I don't believe, the reason I had step 0 in my analysis is that I don't believe that these categories are objective, right? But medical framing can create a veneer of objectivity that lawyers seem to believe in, even as we lose faith in ourselves. And so, as public opinion in institutions like courts have dipped, confidence in medical professionals has remained relatively, I emphasize the word relatively, robust. Courts and claimants draw on the legitimizing force of medicine to back up their own claims. Indeed, as I show in the paper, even where law and doctrine counsel against reliance on medical evidence, right? So in the ADA context, many activists have said, no, we shouldn't talk about this as a medical frame. Courts prioritize, and some might even say hide behind medical evidence to legitimize their decisions. Okay, so far I've shown these medical claims happen, and I've explained why they happen. So this leaves one more question: should they happen? So critics of medicalization and on the legal literature on this issue is fairly one-sided in that direction, right? They tend to argue that using medical frames harms individuals in 3 ways. First, it imposes rigid controls on individuals by converting them into objects of medical supervision, diagnosis, classification, and intervention. And so for those of you who read Foucault in undergrad, right, that's his standard critique. Right? They must also assimilate into medical models to get medicine's advantages. Thus, Dean Spade, who a very well-known trans activist, describes how trans individuals must jump through medical hoops to get medical help. I mentioned Kiara Bridges earlier, who describes how pregnant women of color are forced to comply with draconian regimens imposed on them by state Medicaid programs and remain closely supervised through these programs. Now, much of this, I should note, is justified simply by the stigmatic characterization of the group that has nothing to do necessarily with medical status, right? So poor women of color are considered irresponsible for having a baby in the first place and therefore need to be supervised. Or disabled individuals are helpless and therefore need to have special rights, would be the idea, right? So if you frame it as medical, this is you're going to be stigmatize these individuals in various ways. They're irresponsible, they're helpless, etc. So thus the very rights that the group enjoys through medical frames might signal, these critics wonder, might signal their inferiority, which in turn might be used to justify social control. Another set of criticisms that hasn't really permeated the literature are institutional concerns. So one might caution that it is problematic to use a methodology where so much power is delegated to medical institutions. Protected classes have historically been designated by government institutions. So if you Title VII, constitutional suspect classes, they all offer protections based on criteria developed by courts and legislatures, not by medical professionals. In the context of medical civil rights, the law delegates far more of its power to foreign institutions. And courts might referee competing medical evidence, but a lot of the heavy lifting relies on doctors and other medical professionals. And these institutions lack the constitutional and democratic legitimacy that until maybe a few years ago, courts and legislatures have had. And further, some may fear that deploying medical frames to aid unpopular causes might sully medical frames themselves. Right? So associating medicine with unpopular causes like poverty or unemployment might sap its normative cachet. And third, some may fear that medical frames might be used to promote negative causes, right? So pharmaceutical companies might say, oh, poor people need access to drugs, right, to try, but really they're worried about the bottom line. The criminal justice system medicalizes certain individuals in order to justify some pretty problematic diversion programs that allow deprivation of due process because you take them away from the general criminal justice system. So my core response to all of these objections is that they're either overblown or similar in scale to the harms that legal rights in general present. As a result, the benefits of legal rights outweigh these fairly generic harms. So take the critique of control and assimilation, right? Individual rights critiques. Kenji Yoshino has famously criticized the quote-unquote assimilationist bias of equal protection jurisprudence that forces individuals to pretend, at least, or pretend to toe or assimilate into certain criteria in order to claim constitutional protections. Lawyers must shoehorn narratives into legal categories in order to make legal claims, right? So you've got to say, oh yes, my characteristic is immutable, right? In order to get these protections, even though as a gay rights activist or as an LGBT person, you may not believe things are immutable. And so Kenji talks about how this contributes to bisexual erasure, right? Because there's a question as to how to treat bisexuals and in relation to immutability. Similarly, legal benefits of all kinds can stigmatize. So Justice Clarence Thomas, for example, believes that affirmative action policies can, quote, undermine the self-esteem and dignity of the recipients because they suggest that African Americans need assistance. Other kinds of legal rights seeking can also present institutional concerns. They can be co-opted for a variety of purposes. Consider Fisher versus Texas, for example. And where you have a white woman claiming, using the legal rights structures created by the civil rights movement, saying, I'm facing discrimination. And whatever you believe about the merits of that claim, that was a co-optation of a structure developed for very different causes. Right? And the legitimacy of constitutional rights claims suffer when they involve unpopular causes, as the Supreme Court found when it dealt with the anti-busing controversies of the 1970s and 80s. Right? So all of these problems are true when you use legal rights claims in general. So the benefits of medical civil rights often, though not always, exceed the benefits that other kinds of civil rights claims present, as I outlined earlier. Their costs are relatively similar to those of other kinds of right-seeking strategies. Thus, we would expect that in many, maybe not in all cases, that medical civil rights would be an attractive approach to right-seeking, and the numbers that I put up on the slides earlier bear this out. But like any litigant, those seeking medical civil rights must consider whether in their particular circumstance the benefits outweigh the costs. So that's my core defense. But I also have what I call an aspirational defense. And I believe, though I cannot say for certain, that the nature of medical civil rights will slowly transform to divest medical discourse of some of the flaws that the critics point to. The meaning of medical status, as I suggested at the beginning, is socially constructed and malleable, right? We can change it marginally over time. So, and through sustained activism, a process which allows multiple stakeholders to engage with medical discourse, the nature of medical status can be transformed in ways that no longer coerce, stigmatize, or assimilate, and which increases its legitimacy. If we invoke medical status in legal activism as a source of rights, we can increase its rights-giving potential. Within medical institutions, we should promote ongoing steps to enhance patient autonomy, and those have steadily been increasing since the 1970s. We should promote ongoing steps, so trans individuals, for example, have participated to an unprecedented degree in the formulation of gender-related diagnoses in the DSM-5. Indeed, even lay individuals and non-patients are beginning to invest in medical discourse. So you begin to see individuals engaging with medical institutions even if they aren't quote-unquote sick, right? So preventative care, for example, wellness programs, genetic testing kits, and medical/fitness devices, right? So we're beginning to increasingly see ourselves through biometric frames. This can expand how we think about medical status, its normative valence, and the interest in rights of those who have it. It'll increase the perceived legitimacy of medical status and will create a sort of interest convergence between those who are unwell and those who are well and healthy but see themselves as medical biological beings. Medical civil rights thus rely on both medical recognition and legal rights giving. They are a site of dialogue between law and medicine, where I think law can extract from medicine the liberatory power that I think has always been there, and that critics like Foucault, who wrote in the 1960s, did not recognize at the time. And I think medicine can harness, in turn, law's rights-giving features. I think the law can thus infuse medicine with a normative content in a way that medicine by itself is often ill-equipped to yield. That normative content can be punitive, and it can reinforce the hierarchy of doctor and patient. But I think as medical civil rights, as my talk today shows, it may also be liberatory. It creates a starting point, at least, to think about new forms of rights, positive rights, rights that extend to family, to caretaking, and to social transformation. In so doing, the law also takes from medicine its legitimating power to shore up law's own security. This law is invoked in the visions of real litigants, of desperate parents, and of distressed employees, who invoke medicine not simply for the cures it might provide, but also the rights it might yield. In so doing, it is these individuals and these claims that shape our understanding of medicine, of law, and their ongoing relationship. So I'll stop there, and I look forward to your questions.
So about your stigma part that you
Yeah.
discussed, which I guess a couple things. First of all, I don't know if that concern can be overblown.
Yeah.
Just in my own thoughts. But then secondly, I'm wondering, has there been any writing or what are your thoughts on like maybe individuals who have been more historically considered disabled, if it creates any animosity within their groups towards these individuals who now are using the medical framework to get some of these civil liberties that you discuss.
Yeah, no, absolutely.
Maybe they don't see them as like truly disabled.
Yeah. So great questions. So the first is, but I agree that stigma concerns are problematic ones. I mean, I don't. So I believe that on one hand, the use of rights can stigmatize no matter which way it's used, right? So you have Title VII plaintiffs saying, by filing a lawsuit, by going through this process, I felt humiliated or whatever it is, right? Because I needed to seek rights in this way. So I feel that. So without discounting that, I just believe that that's a problem with legal rights claims in general. And so maybe we need structural solutions, not maybe, we do need structural solutions, right, that don't, require groups, certain groups to identify themselves as needing the assistance of the state to get what they deserve, right? And I think that seeking of assistance is what I think stigmatizes for a lot of people, whatever the kind of rights claim. But I agree, it's a problem that all rights claims face. In terms of boundary maintenance, so it's just interesting, right? Because it's very hard to stake out any one position within any one group, right? So, for example, I would say, one thread of writing within the disability studies community and the disability rights scholars is we need to expand the definition of the ADA. The ADA is being read too narrowly, right? And so many scholars would actually be quite happy to expand the definition, right? There are certainly others who would say, look, these groups should not count, and that waters down the protections for everyone else, right? I think that kind of so gatekeeping has happened again with all groups. So I've done a lot of LGBT rights history, and that certainly happened within the LGBT rights context, right? These individuals are not truly queer or not truly gay or whatever it is, right? And so we should not necessarily include them within our movement, right? And then the final thing, though, reverting back to stigma and gatekeeping, is that I think that, as people engage with seeing themselves as medical beings more and more, so actually, even if you look at the rates of drug taking, right, across age groups, right? And there's no robust. I don't know if robust data on this, but I need to dig around some more on this. It's increased dramatically, right? And so attitudes, I think, towards mental health issues, I feel younger generations are far more okay with that than older generations towards taking certain kinds of drugs that enhance certain abilities, sometimes problematically. Again, I think the younger generations far more okay with it than older generations, right? And so I think there's a sort of destigmatization happening, because if everyone's doing something, how can it be stigmatized? So I don't know. So that would be one. Yeah.
I want to push that.
Yeah.
Tell me your name, because I don't know the names of everybody.
Chase.
Chase.
Yeah.
I want to push Chase's question a little bit.
Yeah.
And this is a short-term question.
Yeah.
So there's a big debate right now about service animals.
Yeah. Yes.
And so what's going
I like
on
that.
is people bringing their ducks onto airplanes,
Peacocks.
or peacocks,
Yes,
or whatever it
peacock.
is, have made it harder for people who are bringing their genuinely trained service animals. So the expanded claims have, in the short run, undermined the real claims of people. So that's one of the concerns disability rights advocates have.
Yeah.
And I'll give you another example. When you were talking, because I was thinking along this same line that Chase raised. I've got a database of ADA cases, and I haven't looked to categorize, but my impression, is that there are a load of cases where people bring an age discrimination, a race discrimination, and a disability discrimination. And the disability discrimination, they kind of gin up in a way. So they try to use the disability discrimination when their real claims are race or sex, which gives disability discrimination claims a bad name. And I would love to look at, and this is a research project for somebody, to look at the civil rights cases where you see a race case, where you see a race claim, a disability claim, and sometimes it's sex too, where you see multiple claims, and sometimes an FMLA claim.
Yeah.
And it's a good sex discrimination claim, but they're never going to get there because courts aren't going to recognize the sex discrimination claim. So they try to shoehorn it into a disability claim, and they get bad disability rights law. Now that's a short-term worry, but I think it's a real worry.
No, I think that's fair, right? I mean, it sort of harks back to the, are we going to destroy the reputation of medicine by associating it with
It's
those
analogous
other?
to that.
Yeah. And so but again, all I can say is that's a debate that happens with all communities, right? Whether it is this group doesn't belong, or that rights claim takes us too far afield, right? So another example that came to my mind as you were chatting is, Ted Olson, David Boyce, please do not bring a gay marriage lawsuit, because that's going to set the gay rights movement back 10 years, right? And so of course, there wasn't a gatekeeping thing, though it was partially also you are not gay people, but it wasn't. But it was, look, you're going too far afield, and so I think that those are debates that just happen. That's the nature of. That's the nature of impact litigation, I feel, and I,
I mean, it actually, you could take an example right from the very beginning of Title VII of the Civil Rights Act.
Yeah.
What did the Southern senators try to do to undermine Title VII?
Oh yes.
Yeah, they brought
Yeah.
that's how sex discrimination got into Title VII. They thought Congress would not pass the employment discrimination title if sex got added in as a category.
No, absolutely. And so just as, trying to include peacock within a definition of a service animal, including sex within the promise of employment equality was meant to to completely, invalidate all equality protections, right? And luckily, it didn't work.
Yeah, although disability rights advocates are really worried.
Yes,
You said that
absolutely,
it might-
absolutely.
Anyway.
So kind of going off of that, it sounds like there's some risks to sort of creative lawyering within these claims, but if you were a practicing plaintiff's attorney who are in impact litigation or you made your living off of bringing these ADA claims, is there anything under this framework that you'd be sort of chomping at the bit to kind of try out that you think might be like, oh, here's a really specific and exciting opportunity that we could explore?
No, that's really interesting. I think for me as someone, I believe that each of these kinds of claims are very area specific, right? And I am by no means someone who is an impact litigator, number one, or a disability rights advocate. Having said that, I do fancy myself an LGBT rights person, though Shannon Winter and Kate Kendall are here, so you can ask them. You can ask them that yourself. And I would actually say Blatt versus Cabela's Retail from a district court in Pennsylvania. I can't remember which one. So the ADA explicitly excludes gender identity disorder, and so that court said, well, so GID is excluded from ADA protections. But I've got to read the statute really narrowly because of its exclusions, it creates the inference of stigma. Footnote, duh. And so I don't want to create constitutional problems by reading statute too broadly. And so I'm not going to consider gender dysphoria as falling within gender identity disorder. The difference, so gender identity disorder is you identify with a different gender from the one that you were assigned at birth. Dysphoria is when that causes distress and you seek medical treatment because of it. And there was a shift between DSM-4 and DSM-5 that said, okay, DSM-5 says GID is no longer a medical condition, but dysphoria remains a condition, right? And so the court said, look, so I'm going to look at dysphoria, it's not excluded by the ADA. That's a massive thing, right? And the fact that the Trump administration seems okay about it is more confusing than anything else, but is also a massive thing, right? So I would love to see it. So there are a bunch of cases filtering their way up. So to me, I find that quite interesting.
Yeah, I was hoping you could talk more about how you would frame homelessness as in the medical framework. Salt Lake specifically, I mean, a lot of cities have this problem, but I feel like in the past few years, Salt Lake has really been grappling with this, and I have worked with that population, and the trending model for the past, 20 or 30 years has been housing first.
Yeah.
But now there's more of a swing towards mental health.
Yeah.
And so I'm curious what your thoughts are on what that would look like, what kind of framework would address homelessness.
Yeah. So is this one of those things where I can call a friend and get Mary Crossley or Dana Matthew? So there are two incredible scholars working on this issue: Mary Crossley at the University of Pittsburgh and Dana Matthew at the University of Virginia, who have been publishing and writing on this for some time. And so this is something you should definitely, and Professor Francis knows them both. But I, my looking at this is simply, so people frame this for advocacy reasons in all kinds of ways, right? To talk about it very broadly. At a very practical level, what's happened is that Medicaid, so are you guys familiar with 1115 waiver programs in Medicaid? So basically, I see some yeses, some no, so I'll just explain it.
Some have had health loss, some have.
Yeah. And so basically, Medicaid allows states to adjust their programs from federal requirements in certain ways. You have to get approval from the federal government, and the idea is to provide services in new and innovative ways. It's being used in some really bad ways right now, but under the Obama administration, they offered waivers that allowed Medicaid to pay for various kinds of housing-related expenses. Now, Medicaid cannot pay for rent. That's prohibited by the statute. It's a statute, yeah, but it can pay for for deposits. It can pay for furniture, moving expenses. It can pay for those various things, right? So that's basically, and so Medicaid's been dispersing payments and some great programs in a lot of great states doing that. There have been expansions. So I was actually talking to the contractor that runs Washington's program, and they're expanding that to include work requirements. No. Sorry, that was just a Freudian slip because that's the waiver program that everyone's thinking about. But to include work assistance. Sorry, but the idea being, look, unemployment is a social determinant of health as well. So we do provide that. And so in Colorado, we're going to start something on that. So I'm supposed to be on subcommittee, and so it's an interesting area. And if you're interested in it, hot area to be in. I would encourage you to look at people who know more about it.
I'm sorry.
So in some of the criticisms you talked about, one that came to my mind is I worry that maybe this could stop some advancements that have happened. Specifically, I'm thinking there's been a lot of state legislatures or cities that have pushed to ban conversion therapy. And this seems like a way that the other side, people who are for conversion therapy, might say, look, you want to call it a legitimate medical condition, then we should be able to treat like that. And so and that's just one example that I can think of. Do you worry that there might be, this could stigmatize, not only stigmatize, but prop up these kind of ways that we perpetuate discrimination against those groups?
So professors love that kind of question because that allows me to talk about my next paper. So full disclosure, so I actually was a lawyer who defended the first ban on conversion therapy in California. I used to work for Kamala Harris out there several years ago.
So the ban?
The ban. So we banned conversion therapy for minors, and basically. And so it's interesting because I got to see a lot of the litigation material there, and absolutely, those were, the medical arguments were advanced. Other examples, so-called trap laws. I don't know if you come across this in the abortion context, right? So these laws that Justice Kagan quipped required abortion facilities in Texas to have standards similar to Mass General, right? And they say, oh no, legitimate medical reasons, and you're like, well, that's completely false, right? And so my belief is that, so number one, just as legal discourse can be used for good or for evil, medical discourse can be as well, right? You've got phrenology, you've got biological differences based on race. I mean, one of my the most interesting diagnoses I came across during this is the diagnosis of tripetomania. I don't know if I'm pronouncing it correctly, but it's the sickness of running away, which only applied to slaves, right? And so the point is that medicine, like law, can be harnessed and can be co-opted, can be used, I think, for various things. Now, I think law is a very parasitic discourse in the sense of it is meant to be co-opted by anything, right? I mean, it's but medicine, I think, has an ethical core that is unique to medicine. What's interesting, if you look at the biblical counseling textbooks within which the social orientation change efforts therapy sort of falls, those textbooks say, look, when, and I'm almost quoting here, when the book of nature and the book of God conflict, you go with the book of God, right? So the idea is that you're not using medicine for what medical institutions and our concept of medicine would say is medicine. You're using it for other ends, right? Similarly, in the case of abortion, right? I mean, no one believes that it's truly a medical motivation, right? The idea is you're smoking out the actual purpose, which is some sort of moral agenda, which is not associated with what we classically believe medical, sort of what medicine is supposed to be dealing with. Criminal justice system as well, right? So I think that yes, medicine can be used in bad ways and in good ways. The question is, right? So what's the best way to prevent this from happening? And I don't think it means that those of us who I think are using it in good ways go and sit in the sidelines and let medicine be completely co-opted by these various groups. I think we sort of join the fight and say, no, this is what the moral core of medicine is. This is what we're claiming, and this is the rights-giving power it can give, right? And so, yeah.
You mentioned that given the medical discourse and the trans individuals have been able to take part of it.
Yeah.
I'm just trying to figure out, you also mentioned in the beginning that in the 60s there were civil rights movement, gay rights movement was trying to go away from medicalization of being gay, and then recently kind of going back towards it, but how do you capture the sentiment or the actual feeling of to me, it just seems like our community is kind of fragmented, and it's hard to really understand what one side is, and especially the trans community is just been disenfranchised for so long. Education is not standard, and it's just very difficult. So I want to know how you actually and how other leaders are capturing the sentiment of what the community throughout the levels and throughout all SESs. How are you capturing the sentiment of what they actually want, as opposed to this is what we want, we're taking you.
So now that's really a question for Kate Kendall and Shannon Minter. Sorry. Yeah. Oh, yeah. Are you going to go to the talk later? Yeah.
Some might come class.
Oh, I see. Yeah. No, so, and I will say that they're one group. So this is then CLR, which is this great group that does wonderful work and actually does care about these issues in a very important way. But it's very hard to ensure that your views are fully representative, right? I'll give you a couple of interesting examples when it comes to gay marriage. So in 1951, I found, because as you know, I like to read like gossipy magazines, right? And I don't mind when the gossipy magazine is from, and so I used to read gay gossipy magazines from the 1950s, right? So some of the first gay publications. And in 1951, an article published by an anonymous person whose name I somehow managed to find, basically said, we should start thinking about homophile marriage, right? This is a gay magazine, right? And the responses were all just very, from other gay readers, like it read like a focus on the family bullet point list, right? But from gay readers, right? And this has remained controversial throughout, right? So you have this debate, Paula Edelbert, the former legal director of Lambda Legal, and Tom Stoddard, who was, I think, the executive director of Lambda Legal, right? Have this great debate that I teach in my sexuality and law class every year. But Paula says, no, we don't want gay marriage. We don't want to buy into the heterosexist, patriarchal institution. All arguments you're familiar with, right? And then you have folks in higher SES groups, right, saying, no, we want to do it. And frankly, funders will say that, in some ways, thank God for Trump's election, because funding for the gay rights movement was dying, because the rich gay white men, who are the main funders of the movement, no longer cared about the other issues that were there, right? So the fact is that, yeah, there are tensions. A lot of the work is driven by certain groups. One tries to figure out what works best. And within the trans community, there is, as far as I can tell, a genuine debate. I think my sense is, frankly, that many trans individuals, I want to be careful here. Many trans individuals would say, look, I don't care how you get it, but I don't want to be fired from my job, right? It's wonderful that you have all your grander theories about reification of medical identity. Great, but I need to put food on the table, right? And so, please, just do it, right? There's another. So in the paper I have an example, and this is going to make you more skeptical of this paper, but I think it's a hard example, which is why I like it. It makes, I think, it helps my argument because it forces me to think about it. So Spotlight, which is not just a movie, but it's the column, right, in the Boston Globe, did this really heartrending series of how parents, in order to get Social Security benefits, medicate their children. Right? Now, of course, it's not just, they don't just sort of say, oh, okay, I believe, they have to go get a diagnosis from a medical professional. They've got to jump through a few hoops that the low-income individuals don't find easy, right? So there's usually something there, right? There's some, but many of them say, I don't want to drug my children, right? But Social Security will not give me benefits. And it's very easy, and the way it's presented, I think, by some people is, well, oh yes, look at these, bad parents, right? Giving medicine to their children. And they're like, yes, but what's the alternative, right? They've got to put food on the table. Because, medication sucks, but starving does as well, And so my claim is that, yes, on a blank slate, medicalization sucks, right, in many ways, but we aren't working on a blank slate, right? We're working on a slate that consists of making very hard choices. And I think that sometimes medicalization is a less bad choice than other choices, right? And that is the core of my claim. I do have the aspirational claim, but I am not entirely sure at all that that's going to transpire.
you also claim, as you do, that at step 0, that medical is historically constructed. Isn't what you just said dangerous?
How so?
Well, so here's my worry. In your answer to Rick, which was the question before that one, you were talking in essence about the legitimacy of medical claims.
Yeah.
And to the extent that you undermine views about the legitimacy of medical claims through a historicization of what they are, there's a tension, I think, in your view.
No, absolutely. So I very much recognizes that I very much recognize, as I think as do all of you, that the emperor doesn't have all those many clothes, or the clothes are very socially constructed,
Yeah.
right? But they aren't real, right? But we treat them in the law as real,
Yeah.
right? But I think at the end of the day, again, I keep going back to my standard defense, which is that is how the law operates, right? I mean, if we stop believing in the law, there would be no law, right? I think with medicine, there is a little more objectivity, if you like, but I mean objectivity in a socially constructed. You know what I mean. You know what I mean. So I will say so that actually this. So I think that there's just so much buying into medical frames right now, right? Among all groups, all I think SES groups, all demographic groups, that they okay. Well, I know that's my cue. I should. But I think that I think the legitimacy will remain. I do not see when 23andMe keep growing their market share when you're I don't know, your Fitbits, whatever. I'm an old millennial, right? So I don't know what it is you folks are using, but I think that people really buy into it. I mean, I think universal healthcare is an example of this. People buy into the fact that medical misfortune is different and has to be protected against. But I don't know. I don't have a crystal ball.
Do others have comments, questions?
I have one more question. It's kind of off from what we've been talking about, but recently a judge in Idaho ordered for Idaho taxpayers to pay for an inmate's gender
Confirmation surgery.
Yeah.
Mhm.
I'm just curious. It says that that this inmate will be the second person in the country to receive it, such a surgery. Do you believe that this will be a trend that will start to happen as time progresses, or do you think these are kind of just two cases that are so specific on their own that?
So it depends on the kind of surgery. I mean, phalloplasties, vaginoplasties, so-called bottom surgeries, and then mastectomies or breast reconstruction, so-called top surgeries, have been happening since the 1960s. I mean, there have been hundreds, if not thousands, of them. Not all trans individuals seek them. It's certainly bottom surgery. I would say a majority of trans individuals do not seek. Is my understanding of the data I've looked at. I don't know whether it's lack of medical access, because the unemployment rates are like 50% in the trans community, or whether it's some other reason, right? But these are actually fairly common. So Iowa actually, just the lower court in Iowa just struck down its ban on Medicaid covering these surgeries. So there were two plaintiffs in that case. Wisconsin, again, very recently, a federal district court this time struck it down. And the Iowa district court did it on state grounds because the 8th Circuit in 2001 had held that the Medicaid rule satisfied. So I wonder whether it's a specific kind of procedure that's a subset of the range of gender-confirming procedures out there. But under the broader umbrella of gender-confirming procedures, I mean, the litigation on this. There was a case when I was at California, at the California AG's office, where we denied an inmate, our Department of Corrections, that were really lovely people, denied an inmate some surgery, and I couldn't work in the case because I was on the board of Lambda Legal as the litigator. But it's really it's the broad category is common. So I don't know if it's a specific kind, but I don't
Yeah,
know.
it just says gender reassignment surgery. So.
Yeah. Who says it's the second one? Did the judge say it's the second one? Or-
No, that's what this article says.
I think it was the second time a state had been ordered to pay for it, is what it was.
Well, so when they say taxpayers, I mean, it just comes out of this general state coffers, right? The Department of Correction coffers, I would imagine. And again, I know California did it all the time. So the case I'm talking about was a case involving prisoners. Similarly, in the Medicaid context, so it happens all the time. In fact, it is, so some argue, I have not looked into this closely enough, but some argue that it is easier to get gender confirmation surgery if you are in prison than if you are under Medicaid, right? I think that's changing, but yeah, I mean, but there have been a lot of cases on this. If you look up Alvin Lee, a piece by Alvin Lee from the Harvard Civil Rights Civil Liberties Law Journal in 2009, you'll see like he lists just a bunch of cases, a bunch of litigation.
Interesting. Well, thank you.
Thank
and
you, everyone.
now
It was
we
so
get to-
interesting.
Now we get the other part of all of
Yes,
this. And they're
absolutely.
cookies and tea.
Amazing.
Yeah.
So civilized. 4:15 tea time. I love it.